All right, listen up. You want to know about criminal law, huh? Well, here's the deal. Criminal law is like the bouncer at the club, okay? It's the system that deals with the bad guys, the ones who break the rules. And it's got all kinds of ways to make him pay, and I don't mean just a little slap on the wrist. Punishment is the name of the game. Now, what exactly is a crime? Simple. It's when you break the law and get hit with some real consequences, not just a speeding ticket or a slap on the wrist, but actual punishment, baby. Punishment is the part where the state gets to play the heavy, right? They're the only ones who get to dish out the pain. And I'm not talking about some old-fashioned torture. No, now we're talking about jail time, fines, loss of freedom, that kind of thing. Money is involved, sometimes even more than your pride. Let's talk about what punishment is all about. It's a response to crime, plain and simple. You mess up, you get hit. It's personal, my friend. You don't just get punished for the crime, you get punished for being the one who did it. No shortcuts. Pain. The stuff nobody likes to talk about. The state gives it to you, and it's going to cost you, whether that's in money, time, or freedom. And here's the big one. Only the state can give you the punishment. They've got the monopoly on this one, pal. You break the law, you answer to them. And here's the twist. Criminal law isn't just some local issue. It's going global, baby! We're talking about international criminal law things like war crimes and genocide, big stuff that crosses borders. And then you've got the EU and the European Court of Human Rights. They've got their finger in the pie too, even though they're not criminal courts. They're all about protecting human rights, but make no mistake, they affect national criminal law in a big way. Now, the ECHR, they're not a criminal court either, but they can still make your life a living nightmare if you mess up. They're all about making sure criminals get a fair trial, but also ensuring victims get justice. They don't just care about the bad guys, they care about the whole picture. So, bottom line, criminal law is about punishing the guilty for breaking the law, but there's a whole international game being played too. You mess up, and the big leagues are watching. If you need advice or a loophole, you know where to find me. Just don't get caught in the system, all right? Keep it legal. Theories of punishment. Breaking down the big ideas. All right, let's dive into punishment, the state's big bad tool for making people pay for their wrongs. But here's the twist. Punishment isn't just about hurting people, it's got deeper ideas behind it. And yeah, those ideas can get real complicated. Why punish? Punishment hurts, that's the bottom line. Whether it's jail time, bye-bye freedom, or fines hello, wallet pain, it's about taking something away. But here's the kicker. Punishment has to have a reason, a justification. Why does the state get to hurt someone who's committed a crime? Well, two big reasons. Deterrence. The whole idea is to scare people into not committing crimes. Punish today to prevent crimes tomorrow. It's like setting up a big "Don't mess with us" sign. Desert. Some folks deserve to suffer. If you commit a crime, you deserve the pain that comes with it. The punishment has to match the crime. Two big theories. Absolute theories. This is the "you did the crime, now you gotta pay" school of thought. Punishment is justified just because the crime happened. Period. No questions asked. It's backward-looking we punish because you've already messed up. Retributionism. You've got this one if you believe people should get what they deserve, no more, no less. If you wrong someone, the punishment should match the harm you caused. Retributionism keeps things fair, and it's about keeping private vengeance in check by giving the state the power to deal out punishment. It stops people from going all eye for an eye on each other. Divine retribution. Back in the day, some folks thought the crime wasn't just against people, but against God. The state was just a vessel for divine justice. So judges were like God's enforcers on earth. Moral retribution, Kant. Kant took this to the next level. He said punishment was a moral duty. You commit a crime and society has the obligation to punish you. Even if everyone agrees to dissolve a society, the last wrongdoer, he's got to be executed. Moral duty, folks. Legal retribution, Hegel. This is the cold, hard law version. Punishment is about keeping the legal order intact. Someone breaks the rules, the system has to restore balance. It's like a reset button for society. Relative theories. These theories aren't just about what you've already done. They're forward-looking. Punishment is about stopping future crimes preventive measures. You hurt today to stop the hurt tomorrow. The idea is that we punish to prevent others from committing the same offenses. Preventive punishment. This theory is all about the future. We punish to create a future where crimes don't happen, or at least happen less. It's proactive, not reactive. The bottom line? When we talk about punishment, we've got two broad camps. Retributionists, who think we punish because you deserve it, and preventionists, who believe punishment is a tool to keep the peace in the future. And yes, they don't always agree, but that's the push and pull of criminal law. It's about striking that balance between justice, paying for past wrongs, and prevention keeping society safe moving forward. So, whether you're talking about the divine right to punish or just restoring order, criminal law is full of competing ideas about how to get justice and who gets to decide when it's enough. Why punish the wrongdoers? So, why is it right to punish wrongdoers? Well, retributionism argues that punishment is justified because of the free will that humans have. People choose to commit crimes, so they should be held responsible for those choices. Mens rea, the mental state of committing a crime, shows that humans are morally accountable for their actions. Key arguments in retributivism: free will and moral responsibility. The core belief here is that people act freely and choose to do good or bad. If someone commits a crime, it's because they chose to do so, and they should be held accountable for that choice. Punishment, in this sense, is a moral response to that choice. Paying back a debt. Another argument for retribution is that criminals owe society a debt. Committing a crime takes something from society, whether it's peace, security, or trust. To restore balance, criminals must pay back this debt, and punishment is how this is done. Removing unfair advantage. Society is based on the idea that everyone agrees to follow certain rules, namely, not committing crimes. When someone breaks that agreement, they gain an unfair advantage over others. Punishment removes this advantage and restores fairness. Implications of retributivism in criminal law. Principle of personality of criminal liability. The idea is simple. Only the person who committed the crime should be punished. No one else is responsible, so no one else should be punished. This keeps things fair and personal. Principle of proportionality. Retribution means that punishment must fit the crime. The severity of the punishment must be proportional to the severity of the crime. It's about matching the harm done with the harm inflicted in the punishment. The punishment must be adequate to the crime. This principle places limits on the power of the state to punish. Punishment must be justified and appropriate, neither excessive nor unjust. Criticism of retributivism. Subjectivity of morality. One of the biggest criticisms of retribution is its reliance on morality. What is right or wrong is often subjective. Different cultures, societies, and individuals have varying ideas of what constitutes moral behavior. If morality is subjective, how can we justify punishment in the way retribution does? Separation of law and morality. The state's role is not necessarily to define what is morally right or wrong, but to ensure the coexistence of society. Some argue that the purpose of the state is not to enforce moral judgments, but to create an environment where people can live together peacefully. Proportionality problem. Determining proportional punishment is not always straightforward. What is proportional in a moral sense can be debatable. How do we balance mercy, compassion, and forgiveness with the idea of just punishment? The idea of forgiving or showing mercy often complicates the notion of strict retribution. Conclusion. Retributivism certainly provides a strong moral foundation for punishment, but it can't be the only justification for the state's right to punish. It raises questions about morality, the subjectivity of punishment, and the role of the state in shaping what's right and wrong. While retribution is a compelling theory, it is far from the final word on why we punish. There's a need for a broader discussion on that can take into account the complexities of justice, mercy, and social order. Preventive theories. This is where punishment isn't just about paying for the past, it's about looking forward. We punish to prevent future crimes, keep society in check, and make sure the bad guys think twice before they do it again. We're talking about deterrence. It's all about making crime unappealing. because no one wants to deal with the consequences. You get me? Now, here's the 2-for-1 punch of prevention. General prevention. This is like sending a message to everyone. You mess up, and we punish. We want everyone to see what happens to the bad apples, so they think twice before breaking the law. It's a warning shot to society. Don't do it. Special or specific prevention. This is more personal. We don't just punish to make society see the consequences. We want to make sure the offender gets the message loud and clear. Don't do it again. You make them hurt enough, they'll stay out of trouble because no one wants to go back to jail, right? Enter utilitarianism, the idea that everything, including punishment, should be about maximizing happiness for the greatest number of people. Think of it like a balance scale. Pain on one side and greater good on the other. If the pain of punishment prevents crime and protects society, then it's worth it. Bentham. This guy, he thought punishment was evil in itself, but justified it only if the benefit to society was greater than the harm it caused. So, for Bentham and his buddies, the question is, will punishing this guy make society safer? Will it stop future crimes? If yes, then go for it. Punishment isn't about getting even, it's about making the whole community better off. Now, how does punishment stop crimes? Well, humans, according to utilitarians, are just rational calculators. They weigh the costs and benefits of doing something. If committing a crime seems like it's worth the risk, the law better make sure that cost punishment is high enough to outweigh the benefit the crime itself. Make the pain of getting caught greater than the pleasure of committing the crime, and bam, you got deterrence. Here's the kicker. General deterrence. You punish one person and everyone else gets the message. Don't mess with the law or you'll regret it. It's the public lesson. Specific deterrence. You punish the individual and you make sure they're scared straight. They'll remember that pain and think twice before committing again. It's the personal lesson. To wrap it up, in the world of utilitarianism, punishment isn't just some random act of vengeance. It's a tool to prevent crime, protect society, and keep things running smoothly. Pain for a greater good. And if you need someone to show you how to make that pain work for you, you know who to call. Immanuel Kant. Big name, right? He's got some serious bones to pick with the idea of punishment as a deterrent. Kant says human beings should always be treated as ends in themselves, not as mere tools for some greater purpose. So, when you use someone to deter crime, making them a pawn in the game to prevent other crimes, you're disrespecting their humanity. People aren't just objects to be manipulated for some bigger goal. Now, let's talk about proportionality. Here's the deal, if you're just going full throttle on deterrence, you might be meting out disproportionate punishment. The idea is harsher penalties must deter more crime, right? But Kant would say that's morally unjust. Just because a punishment may stop a crime doesn't make it the right thing to do. Pure deterrence logic could end up being brutal and morally off the charts, especially if it's not in line with a crime committed. From an empirical perspective, you've got to ask, does punishment actually deter crime? And the answer, according to some folks, is no. What really deters crime is the likelihood of getting caught, not necessarily the punishment itself. Why? Because humans aren't robots. They don't always calculate risks and rewards like a machine. Emotions, personal motivations, impulse, all of that plays a bigger role than you might think. Terrorists, oh boy, they're a classic example. They're not weighing the costs and benefits of their actions like a rational person might. They've got a whole ideological drive behind their actions, so no amount of punishment will change their game plan. They're in it for reasons beyond just avoiding jail time. But wait, there's more what about the idea that punishment actually deters the criminal from reoffending? That's the last objection. Prison may not be the magic cure for criminal behavior, and in fact it could have the opposite effect, criminogenic effects. What's that mean? Basically, prison may teach inmates to be better criminals. You throw someone in jail, and guess what? They're surrounded by other criminals who are all sharing tips and tricks on how to break the law. Over time, the prison itself can normalize criminal behavior. Inmates start thinking, I've done my time, I'll just go back and do it again. It's a vicious cycle. So, in short, Kant says punishment as deterrence disrespects people's dignity. The proportionality argument says that overly harsh punishment is unjust. The empirical criticism questions whether punishment actually works to deter crime, and if it does, whether it's punishment or just the fear of getting caught. And don't forget, prison might actually be counterproductive, teaching inmates to be better at crime, not stopping them from committing it. You see what I'm getting at? It's all about questioning whether punishment is the right answer, or if it just feeds the beast of crime in a different way. Food for thought, my friend. You're looking at criminal law like a game, right? The system's all about punishment, but not just any punishment. We're talking about how it's going to shape society and keep folks in line. Negative general prevention, this one's simple. It's like your mom telling you not to touch the stove because it's hot. You're going to get burned, period. We make the punishment scary enough so you don't even think about breaking the law. It's like putting the fear of God in them. You mess up, boom, consequences, baby, deterrence. Simple as that. But here's the kicker: positive general prevention. It's not about scaring people into compliance. No. It's about teaching them how to be decent citizens. You don't just lock them up and throw away the key. You show them the ropes, give them the tools to do better, and hopefully they turn out as productive members of society. You don't want them to just fear the system. You want them to respect it. Kind of like a Jedi mind trick, except you're getting them to internalize the rules voluntarily. Now, let's talk spatial prevention. And I don't mean outer space, all right? This is about where we put the criminals and why. Negative spatial prevention, the name of the game here, is incapacitation. Lock them up. You take the problem off the streets. Can't commit crimes if you're behind bars, right? It's like a timeout for grown-ups. You don't want to deal with them? Put them in the pen, and that's that. Simple. Done. Positive spatial prevention, but hold on. That's not always the way to go. Sometimes you got to rehabilitate the guy. Maybe he's a repeat offender because he's broke, doesn't know how to read, or got hooked on something. You teach him. You don't just lock him up. You give him a shot at changing. You send him to school, maybe a job program, and bam! You just might get a reformed citizen out of the deal. You fix the cause, not just the symptom. Bottom line, it's all about choice. You can scare people into doing the right thing, deterrence, or you can give them the tools to become decent folks, rehabilitation. So, which one do you prefer, huh? You want the stick or the carrot? Whatever it takes, we'll figure it out. Just remember, the system is there for you to use wisely. Some criticisms of spatial prevention. And, my friend, we've got a whole buffet of issues to pick from. So let me serve you the main course. 1. Incapacitation. You think locking someone up in a cage keeps them from committing crimes, right? Well, hold your horses. This could lead to long, unjust sentences. Not just that we're talking about human dignity going out the window. If we treat someone as a danger to society and throw away the key indefinitely, guess what? We're treading dangerous waters here. You can't just keep tossing people in prison without it being proportionate to the crime they committed. It's like slapping a sledgehammer when a fly swatter would do. 2. Individual deterrence. This old chestnut. You lock them up and they learn their lesson, right? Wrong. Incarceration actually has a criminogenic effect. That's a fancy way of saying prison might make them worse. You toss someone in with other criminals, and guess what? They're going to pick up better or worse crime strategies. Prison doesn't fix people, it just feeds them into a criminal cycle. You want to turn them around? Prison's not the answer, pal. 3. Rehabilitation. Here's where it gets spicy. Rehabilitation was king for a while in countries like Germany and Italy. The idea? You fix the criminal, turn them into a contributing member of society. But here's the twist. It doesn't always work. Studies show little evidence that punishment can rehabilitate. And even if some programs do work, it's still a moral dilemma. If we treat criminals as subjects to be educated or fixed, doesn't that infringe on their self-determination? Is it right to manipulate someone's mind to fit a certain mold? In totalitarian systems, that's a scary road. And even in democracies, it feels like we're turning criminals into lab rats. Not good, right? Restorative justice. Hold on to your seat, because here comes the game changer. Restorative justice. Now, we're not talking about punishment, we're talking compensation. Forget prison and all the deterrence talk. The idea is to bring the victim and criminal together, to restore what's been broken. The state acts as the middleman, making sure both parties are protected and that justice isn't just about revenge. It's about healing, not just punishment. Constitutional framework. Now, let's talk law. Italy's constitution, it says punishment should aim at rehabilitation. Doesn't mean it's guaranteed to work, but the state should at least try. The catch is, they can't force rehabilitation. The criminal can choose not to take part. But don't forget, the state's got a duty to give the criminal all the tools they need to better themselves. But here's the kicker. The state can't just punish however it wants. It's got to stay within the limits of rehabilitation. This doesn't fly in all constitutions, though. In the US, the Constitution doesn't even touch this issue. It's basically Wild West when it comes to deciding the purpose of punishment. The 3 stages of punishment. Let's talk about the 3 phases of punishment. Threat stage. Before a crime is even committed, the state threatens punishment to prevent crime. It's like putting up a big neon sign. Don't commit a crime or else. But hey, it's got to be proportional. You can't threaten a sledgehammer for a paper cut. Sentencing phase. This is the infliction of punishment. And here's the thing, if deterrence is the only goal, you could end up with inhumane sentences that make you wonder if the person's a criminal or if the state's just abusing its power. You have to consider rehabilitation too. People deserve a chance to become better citizens, not just be treated like tools in the machine. Enforcement phase. This is where the punishment is carried out. The state can't just throw a punishment at someone because it feels like it. It's got to balance all purposes: preventive, rehabilitative, and proportional. Retribution is not the end-all be-all. It's a part of the puzzle, but it can't dominate. Proportionality. At every phase, the punishment must fit the crime. You don't hand out a life sentence for a jaywalking ticket, my friend. That's where culpability comes into play. How much blame does the criminal deserve? You can't just blindly slap a sentence on someone. It's got to make sense. Proportionality is your safeguard to avoid becoming a tyrant. Wrapping it up, in the end, you've got to balance. Punishment should not be about just hurting someone or making an example of them. It's got to take into account rehabilitation, proportionality, and the fact that people are humans, not just subjects to experiment on. So don't let the system turn into a monster. It's about justice, not revenge, my friend. Now, you've got the lowdown on this, so choose wisely when it comes to navigating this legal jungle. Here's the rundown on the principles that keep the state's punishment powers in check. Think of these as the guardrails preventing the system from going off the rails. 1. Rehabilitation. First off, punishment has a purpose, and no, it's not just to make the state feel powerful. Rehabilitation is at the heart of the Italian Constitution Article 27(3) and the Spanish Constitution Article 25(2). The state is required to make an effort to rehabilitate the offender. This means they have to offer something more than just locking a person up. They have to offer programs or means to help the convicted become productive members of society again. Imagine being stuck in a rut and having a chance to get out. That's the principle here. Punishment isn't just about punishment. It's about giving people a chance to change. 2. Proportionality. Next up, we've got proportionality, and this is where things get spicy. The idea here is simple. The punishment should fit the crime. A theft shouldn't get the same punishment as a bank robbery. If the system starts handing out equal punishments for drastically different crimes, not only does it undermine the system, but it might even encourage criminals to do worse. A disproportionate sentence might make an offender think, well, if I'm getting this much for stealing a car, I might as well rob a bank for the same sentence. This undermines the whole point of punishment. Theoretical grounds of proportionality. Retribution. This is the oldest trick in the book. The punishment should be commensurate with the crime. The criminal deserves the punishment based on the severity of their crime. Preventive purposes. You think harsher punishment deters crime, right? Wrong. If it's too extreme, it doesn't prevent crime, it could fuel it. Imagine, you get slapped with a ridiculous sentence for a petty crime. You'd be angrier, maybe even more willing to commit more serious offenses down the line. A disproportionate punishment might not only fail to deter, but might even increase criminal behavior. 3. Prohibition of inhumane punishments. Let's get this straight: inhumane punishments are a no-go. No torture, no cruel, degrading treatment, nothing that could seriously hurt a person's dignity. This is where we take a hard line to make sure the system doesn't cross the line into barbarism. We're in the 20th century, not the Dark Ages, so let's keep the system civilized. Treat people like humans, not like animals. 4. Prohibition of capital punishment. Here's a biggie. Capital punishment, the death penalty, is a big no-no in most modern legal systems. It's abolished in most democracies because it's seen as irreversible and inhumane. In some places, there's even an outright constitutional prohibition against it. What's the logic? Once you take someone's life, you can't take it back. It's not just a moral issue, it's a legal one too. We don't want the state becoming the executioner. There are just too many risks involved. 5. Limits concerning life imprisonment. Last but certainly not least, we've got life imprisonment. While it's not outright banned, there are strict limits. Life sentences can't just be handed out willy-nilly. First off, it's got to be proportionate to the crime committed. And second, life imprisonment cannot mean that the person will never see the light of day again. You can't just lock someone up for life without the possibility of reform. Remember, rehabilitation is a key principle. If the person has shown they're ready to rejoin society, they should be given the chance. We're talking proportionality, rehabilitation, and punishment limits, like we're discussing a hot new case in the courtroom. No need to sit through the boring legal mumbo-jumbo when you've got me to lay it all out nice and easy. Proportionality, what's the big idea? Here's the deal. Punishment has to be fair. You get it, right? You don't go tossing a life sentence on a guy who swiped a candy bar. Nope, that's not how we do things. The punishment has to match the crime. It's like when you're negotiating a deal. You want fair value. No overpaying, no underpaying. You gotta hit the sweet spot. Art. 49 of the European Charter of Fundamental Rights. It says it plainly. No penalty should be too severe for the crime. So, if you knock over a liquor store, I'm not saying you deserve life behind bars, but you better be paying the price. It's all about fairness. The principle's limiting punishment. But hold on, just because the law says you've been caught, doesn't mean the state can do whatever they want. Proportionality, my friend, limits the type and amount of punishment. Think of it like a ruler the judge has to use. Rehabilitation. Look, folks don't just need to be punished, they need a chance to get their life back on track. Article 27 of the Italian Constitution, you like that, right? Says punishment's gotta be about fixing the guy. We're not sending you to jail just to make you rot, we're getting you on the right path. Rehab, baby. Proportionality. You can't slap a guy with a bigger punishment than what he deserves. If you're making a deal, you gotta keep it fair. If you punish too much, you're asking for trouble. You're not helping anyone. In fact, you might be making the situation worse. You think throwing the book at some petty thief is gonna stop crime? Think again. It's like overbaking a pizza, you just end up with charcoal. Inhumane punishment? We're talking about cruelty, no one wants that. Torture? Amputation? Please, not in the 20th century. We got standards, my friend. And most countries know it. You can't just throw people in a dungeon and expect them to learn a lesson. It's about keeping things humane. If you're still pulling that ancient throw 'em in the dungeon business, you better get a new playbook. What happens when the punishment's too much? Look, if you make the punishment too severe, you're stepping on dangerous ground. It's like a lawyer going for too much money in a settlement, you might just lose the case. Punishments that are too harsh aren't just cruel, they don't even work. They might even backfire. You ever heard of the deterrent effect? Yeah, putting someone away for life isn't always the answer. It could make them more of a criminal when they get out, rather than less. The state can't just punish anyone like it wants. So here's the kicker. The state can't just say, hey, I'm punishing you because I feel like it. Oh no, you got limits. You can't just throw someone in jail without the right reason. The law's got your back to make sure it's humane and fair. To wrap it up, my friend, proportionality ensures you don't get a life sentence for stealing a loaf of bread. And the rehabilitation part makes sure the system's not just trying to break you, but fix you. And don't even think about cruel punishments, those days are over. We're all about fairness, equality, and making sure justice is done the right way. Just remember, don't do the crime if you can't do the time, but let's make sure the time fits the crime. Article 3 of the European Convention on Human Rights ECHR. This is huge in criminal law. It's like a shield protecting individuals from the state's power to punish. It's a bold statement. No one shall suffer torture, inhumane, or degrading treatment or punishment. What does this mean for you? It means you have a tool, a legal weapon, that protects your human dignity against the state's abuse. Now let's break it down. Torture versus inhuman versus degrading treatment. Here's the difference between these three concepts. Torture. It's the real deal. We're talking deliberate, inhuman treatment that causes serious suffering. Think about the kind of pain that's intentionally inflicted, designed to break a person physically or mentally. It's a level of suffering that goes beyond normal. This is the worst of the worst. Inhuman treatment. This is severe suffering too, but it's a bit more subtle than torture. We're still talking about harmful actions that cause intense physical or mental suffering, but it might not have the same malicious intent as torture. It goes beyond the inevitable suffering of being treated in a lawful way. It's suffering that's unnecessary and cruel. Degrading treatment. Now this one's about humiliation. We're talking about things that make someone feel inferior, humiliated, and belittled. It's not about the physical pain, but the psychological impact. It's like when someone's treated like dirt, that feeling of fear, inferiority, and shame. It's about attacking the dignity of the individual. What's the big deal? This absolute prohibition means that no matter what, even in times of war or during public emergencies like terrorism, there is no excuse for treating someone this way. The European Court of Human Rights has made it crystal clear. This is non-negotiable. This is a fundamental principle of international law. Even if the state tries to justify these treatments under the guise of public interest, there's no getting around it. No exception. You can't cross that line. In other words, if the state thinks it can get away with torturing, degrading, or inhumane treatment under the banner of justice, not on my watch. This principle stands tall and proud, ensuring that human dignity is always respected. The state is bound by this law, and you as an individual have a right to demand protection against it. So, when you're up against the system, remember, Art, 3 ECHR is your line in the sand and no one gets to cross it. Case law related to Article 3 of the European Convention on Human Rights ECHR, which tackles the prohibition of inhuman and degrading treatment with respect to conditions of detention. Key issues. Prison overcrowding. This can absolutely lead to conditions that violate human dignity, because when inmates are packed like sardines, it's impossible to provide them with the basic rights and living conditions they deserve. Case example, Sulejmanovic v. Italy. In this case, the court found that the inmate was confined to a tiny space, which resulted in inhumane living conditions, a direct violation of Article 3. Another case, Torrigiani v. Italy, wasn't just a one-off, but a structural problem. The court found that prison overcrowding in Italy was so severe that it violated Article 3. The Italian state was then ordered to adopt structural reforms and compensate prisoners whose rights were violated. This led to the Cartavia reform, which aimed to reduce incarceration. Just because you've got a lot of prisoners doesn't mean you can treat them like animals. But here's the kicker. The court isn't too strict on space requirements anymore, as long as the time spent in overcrowded conditions isn't too long. If you can prove it's not a big deal, maybe the state can wiggle out of some penalties. Hygienic conditions. We've got contagious diseases popping up in some prisons due to poor conditions. Russia, for example, had some cases where inmates contracted diseases because of terrible hygiene. Case example, Pakimov v. Russia. In this case, prisoners in Russia suffered because of the unsanitary conditions they were kept. Solitary confinement. Is it inhumane to put someone in a cell with zero contact from the outside world? The court says not necessarily. Sometimes it's justified, but only when it's necessary and for limited time periods. Case example, 41 BIS regime in Italy. This special incarceration system is reserved for serious crimes like mafia or terrorism. While solitary confinement is a part of it, the court said it's acceptable in some cases like Vincenzo Provenzano v. Italy, 2018. Provenzano, despite his severe health conditions, stayed under 41 BIS, and the court found it wasn't a violation of Article 3 because he was a high-risk criminal. However, Italy was later condemned because there were no reasons for keeping him isolated once he was no longer a threat and couldn't get proper health care. Ouch! The prohibition of capital punishment. Now, on to the big one, capital punishment. The death penalty is still in play in many places, and the number of executions hasn't dropped like you might think. Most countries have abolished the death penalty, but over 60% of the global population lives in countries where it's still active or legally permitted. The US, the Middle East, and Belarus come to mind. 2022 saw almost 900 executions, a rise from 2021's 500. However, many of these numbers don't even count China, where death penalty stats are a state secret. And get this. Some death penalty sentences aren't for murder. You've got people getting executed for drug-related offenses. In summary, Article 3 is all about ensuring that the dignity of prisoners is never compromised, whether it's through overcrowded prisons, poor hygiene, solitary confinement, or capital punishment. These human rights violations are something that courts are serious about, and when they see violations, they won't hesitate to act. So, when the state decides to punish, they need to play by the rules. And if they don't, you're going to want to call Saul. Is capital punishment legitimate? Moral grounds. Pro, the retributive argument. An eye for an eye. If someone murders, they deserve to be killed. The idea here is simple: retribution. A person who takes a life should lose their own. This is just and right. Con, the anti-retributive argument. But, hold on. Moral values are subjective. What one person deems just might not resonate with another. In modern society, we should rise above revenge. The state has no right to take away a person's life, regardless of their crime. Beccaria, the guy who wrote the book on criminal law, literally argued against the death penalty in On Crimes and Punishments. He believed that when people leave the state of nature and form a society, they give up some freedoms. But no one ever gave the state the right to take their life. It's a fundamental right, the right to life, that can't be surrendered. Practical grounds. Pro-deterrence argument. Capital punishment as a deterrent. Some believe the fear of death stops people from committing heinous crimes. The theory goes, if people fear the ultimate consequence, they'll think twice before committing a murder. Also, it prevents that murderer from committing more crimes. They're dead after all. Con, the Beccaria critique. Beccaria was having none of it. He said, the death penalty doesn't deter anything. Public executions, for example, were just a momentary spectacle. They didn't change minds or reduce crime. Instead, life imprisonment is far more effective because it's a long-lasting punishment that people actually fear more. Empirical studies have shown that death penalty is not more effective than life imprisonment. The US, which has capital punishment, has a higher murder rate than Europe, which generally doesn't. A study in 2006 found no significant difference in homicide rates between US states that use the death penalty and those that don't. Here's the truth. People commit serious crimes because they're passionate or impulsive enough, because they're rationally calculating the consequences. The death penalty doesn't factor into that. Other arguments against capital punishment. Risk of executing the innocent. If a mistake is made, there's no fixing it. Once someone's dead, there's no way to bring them back. Between 1,963 and 2004, 600 people in the US were exonerated after being sentenced to death. That's 1 in every 7 people who might have been innocent. It's a roll of the dice, and the stakes are too high. Arbitrary and discriminatory, capital punishment isn't fair. Studies show that it's discriminatory people of lower economic status or certain racial backgrounds in the US, particularly black people, are more likely to be sentenced to death. Those who can't afford a good lawyer are at a huge disadvantage. It also tends to target certain types of crimes. If a white person is murdered, the punishment is often more severe than if the victim is black. Cruel and inhuman treatment. The methods of execution, whether it's the electric chair, lethal injection, or firing squad, always involve suffering. There's no human way to kill. And then there's the psychological torment of death row. Prisoners live in a constant state of fear and uncertainty, not knowing when the execution will take place. Many prisoners on death row spend decades waiting for their fate. More than half of death row inmates in the U.S. have been there for 18 years or more. In summary, Saul Goodman style, is capital punishment legitimate? Some say it's just to kill a murderer. Others argue we've moved past revenge and that the state has no right to take someone's life. When we look at the practical side, there's no proof it deters crime more than life imprisonment. And then there are huge risks like executing the innocent and the whole discriminatory system of it. Plus, when you think about the inhuman ways it's carried out and the torture prisoners endure while waiting, it's hard to justify. Bottom line, there's a real moral and practical case for leaving the death penalty in the past. The Saul Goodman method might be to keep the courtroom drama alive, but when it comes to life and death, it's too high a price to pay for a flawed system. On the normative grounds for the abolition of capital punishment, there is strong legal backing both at the European and international levels. Let's walk through the foundational arguments that create a solid framework for its abolition. 1. Right to Life European Charter of Fundamental Rights. Article 2, 1 of the European Charter of Fundamental Rights. Everyone has the right to life. This is a fundamental, inalienable right that forms the core of human dignity and cannot be violated, even by the state. This principle underpins the argument that no government should have the power to take a life, as doing so would be contrary to the very essence of human rights. Article 2 of the European Convention on Human Rights, ECHR, also provides for a narrow exception, stating that no one shall be deprived of his life intentionally, unless it is following a court conviction for a crime where capital punishment is provided by law. However, this exception has been limited over time. 2. Abolition of capital punishment in peacetime and under all circumstances. Protocol No. 61985 of the ECHR, which abolishes the death penalty in peacetime, has been signed by all Council of Europe member states, except Russia, which maintains a moratorium on its application. This is a clear indicator of the trend towards abolition in Europe. Protocol number 13/2003 further strengthens this abolition by eliminating the death penalty in all circumstances, even during war or armed conflict. It has been ratified by all Council of Europe member states, except for Armenia, Azerbaijan, and Russia. The exception of Armenia has been significant, as they have signed but not yet ratified the protocol. 3. National constitutions. Several national constitutions within Europe explicitly prohibit capital punishment. For example, Italy, Article 27, 4 of the Italian Constitution explicitly bans the death penalty. Spain, Article 15 of the Spanish Constitution prohibits it as well. Germany, Article 102 of the German Constitution forbids capital punishment. France, Article 66(1) of the French Constitution similarly bans it. These provisions underscore a unified stance across Europe against capital punishment. 4. Europe as a death penalty-free area. Across 47 Council of Europe member states, capital punishment has been abolished. The only exception is Belarus, which still applies the death penalty. However, Belarus is not a part of the Council of Europe, meaning it does not fall under the influence of European human rights law. 5. Death row and inhuman treatment. The long periods of time that prisoners spend on death row waiting for execution are increasingly viewed as a violation of the prohibition of inhuman and degrading treatment. This was addressed by the European Court of Human Rights, which found that the psychological torment endured by prisoners on death row for years constitutes a breach of their human dignity and rights. Conclusion: a clear legal framework for abolition. Europe has strongly moved away from the death penalty through its legal instruments such as the European Charter, protocols, and national constitutions, creating a clear consensus on its abolition. While Belarus remains an outlier in Europe, the overarching trend is one of protection of life and dignity, making Europe a death penalty-free zone. This legal foundation shows how the death penalty is increasingly seen as an anachronistic and inhumane punishment, which has no place in modern, civilized societies that value human rights and the right to life. All right. Let's talk capital punishment and the good old European Convention on Human Rights, huh? Imagine this. You're in a tight spot. Maybe you're looking at extradition. And here comes the ECHR, that's the European Court of Human Rights. Folks, and you're wondering, can they really send me to a place where they might execute me? Well, guess what? They can't, at least not without some serious scrutiny. Why? Because according to Article 3 of the ECHR, we're not just talking about punishment here, we're talking about inhumane treatment, Tan. Trust me, death row is no picnic, my friend. Take the Soering case, for example. You've got this young guy, Soering, fresh out of the gates in the US, committing a serious crime, then running off to the UK like a rabbit. The U.S. comes knocking, asking the UK to extradite him back. Now here's the kicker. Soering saying, hey, don't send me there. I'll be stuck in a death row cell for who knows how long, with the fear of execution hanging over my head like a guillotine. That's gotta be cruel and unusual, right? And guess what? The ECHR agrees. Not about the death penalty itself, no. No, they're not saying the death penalty is a violation of Article 3, but they are saying the conditions of being stuck on death row, the psychological torture, the fear, the waiting for death, it's all a little too much, and that's inhumane. Long wait, bad conditions, mental suffering? Oh yeah, that's where you draw the line. Here's the takeaway for all of us. The ECHR says it loud and clear, if you're gonna send someone back to a country with the death penalty, you better be sure they won't be treated like an animal, sitting in a cell with death hanging over their heads. If you can't guarantee that, boom, it's a violation of Article 3. So, here's the bottom line. Capital punishment itself isn't inherently a violation, but if the conditions leading up to it are torture like waiting on death row with no end in sight, then that's a whole nother ballgame. That's when you've got a violation of human rights on your hands, my friend. And let me tell you, the ECHR is watching closely. The European Court of Human Rights, ECHR, with all its wisdom and experience, has clarified that capital punishment in itself isn't necessarily a violation of Article 3, which bans inhuman or degrading treatment. Bhutan, this is crucial. The conditions surrounding the death penalty can indeed cross that line into a violation. Let's get into it. Death penalty alone. The ECHR is saying that the mere imposition of the death penalty doesn't automatically breach Article 3. After all, Article 2 of the ECHR does allow for capital punishment in certain circumstances, like war crimes or crimes under specific laws. But here's where things get dicey. Conditions of death row. What can be a violation is the long wait before execution, especially when it comes to the harsh conditions of death row. If you're locked up for years, living under the constant threat of execution in a place where your mental and physical health are deteriorating, that could very well count as inhuman and degrading treatment. Extradition concerns. Now, let's talk about extradition. The ECHR made it clear that if you're extraditing someone to a country where they face the death penalty, and you don't have some assurance that the execution won't happen, that's a violation of Article 3. Why? Because you're exposing someone to inhumane conditions, like the mental torment of waiting on death row with no guarantee of their life. Case law, Al Sadoun and Mufti v. UK 2010. Let's bring in some real-world action. 2 Iraqi soldiers, accused of killing American soldiers, were facing execution by hanging in Iraq. They asked to be extradited to the UK for a fair trial, but the ECHR ruled that sending them to Iraq where they faced the death penalty would violate Article 3. Why? Because death penalty is now prohibited in the Council of Europe, and the court said that death penalty is inherently inhumane. Execution involves pain, and in the case of these soldiers, extraditing them to face a possible execution violates their right to be free from inhuman treatment. So in essence, death penalty itself isn't a breach of Article 3. But the conditions around it, long waits, mental suffering, painful execution scan, cross that line. Extradition to a country where you face the death penalty without assurances against it is a violation of Article 3. The takeaway? If there's a real risk that someone will face execution and suffer inhuman conditions like years on death row, then Article 3 gets triggered and the ECHR says no way. Capital punishment? It's just too cruel, my friend. Life imprisonment, now that's a sentence that's a bit of a paradox. It's meant to be a harsh punishment, yet it doesn't always mean what it sounds like. In most European countries, life imprisonment doesn't necessarily mean for life in the absolute sense. Instead, after a minimum term, prisoners are often eligible for parole, provided they meet certain conditions. Once freed, they're typically under probation. In some northern countries, like Norway, life sentences are lighter, with minimum terms as short as 12 years. Others, like Italy or Belgium, set a minimum of 22 to 30 years before eligibility for parole. Some countries, like the UK, leave the decision up to the judge, with the average minimum term being 15 years. However, in the most serious cases, judges can impose a whole life order, meaning the individual serves their sentence without the chance of parole. On the other hand, the U.S. tends to have life without parole as a common practice in many states, where the individual remains incarcerated indefinitely with no possibility of early release. Legitimacy and human rights considerations. Is life imprisonment a legitimate punishment, or does it infringe upon human rights? That depends on how it's structured and whether it allows for rehabilitation. Here are some points. Rehabilitation obstacle. Life sentences can be viewed as a barrier to rehabilitation, which is considered a primary goal of punishment. The idea is that punishment should help rehabilitate the offender, giving them a chance to reintegrate into society. Eligibility for parole. The key factor in determining whether life imprisonment violates human rights is the possibility of parole. If a prisoner is not eligible for parole, they may face life imprisonment without any chance of release, which the European Court of Human Rights considers inhumane and degrading treatment. However, in countries like Italy, the Constitutional Court has ruled that as long as parole is a possibility after a certain period, life imprisonment is not a human rights violation. EU Court stance. The European Court of Human Rights does not focus specifically on rehabilitation, but on the prohibition of inhuman or degrading treatment. Life imprisonment without any prospect of release can cross the line into a violation of human rights. However, if there's a chance of release like parole, the sentence doesn't violate rights, as long as the prisoner is still dangerous or unrehabilitated. This doesn't guarantee release, but it offers a chance based on good behavior or successful rehabilitation. So the takeaway is, life imprisonment is not inherently a violation of human rights as long as there's a chance for release, whether through parole or other conditions. Life imprisonment can be seen as inhumane if there's no chance of release, essentially locking the prisoner away with no future prospects for rehabilitation or reintegration into society. The sentence serves as a severe punishment, but, in a way, gives prisoners a pathway to redemption through the possibility of parole. Without that path, it risks crossing into a human rights infringement. Leading case: Vinters and others versus UK 2013. In the 2013 Vinters and others v. UK case, the European Court of Human Rights ECHR examined whether life imprisonment could violate Article 3 of the European Convention on Human Rights, which prohibits inhuman or degrading treatment. The court held that life imprisonment itself does not violate Article 3, but outlines specific circumstances under which it could. These conditions include gross disproportionality. If the life sentence is deemed grossly disproportionate to the gravity of the offense, this could potentially violate Article 3. However, it's challenging for the court to declare a sentence disproportionate unless it's exceptionally severe in relation to the crime committed. Irreducibility. If a life sentence is irreducible, meaning there is no possibility of early release or review of the sentence, it could violate Article 3. The court stated that life prisoners should have prospects of release after a set period and should know what they need to do to be considered for release. The right to hope for rehabilitation is central to ensuring that the sentence is not inhuman or degrading. Case Overview Vinters and Others v. UK. In this case, 3 applicants were convicted of murder in the UK and sentenced to whole life orders. Under the UK's Criminal Justice Act, life sentences for murder are mandatory, and the whole life order means that the individual remains in prison for life, unless released on compassionate grounds, typically for terminal illness or incapacitation. However, the applicants complained that the discretionary release process was unclear and only applied in very narrow circumstances. The court found that while the state has discretion to set the length of a sentence, a whole life order can violate Article 3 if it is grossly disproportionate to the offense, which is a rare determination. It is irreducible, meaning there is no real prospect of early release or sentence review, which infringes on the right to rehabilitation. In conclusion, the court ruled that whole life orders could potentially violate Article 3 if they exclude any possibility of release or review. The compassionate release provisions in the UK were deemed too narrow to provide a meaningful opportunity for rehabilitation, leading to the court's decision that the applicant's sentences violated their rights. Impact on the UK system. After this ruling, the UK government modified its approach, expanding the scope of compassionate release and emphasizing the right to review sentences, allowing for the consideration of the potential for rehabilitation. However, the core system for life sentences in the UK remained largely intact. Life imprisonment in Italy. In Italy, life imprisonment has a minimum term of 26 years before parole eligibility. However, certain prisoners, such as those convicted for organized crime, e.g., mafia, terrorism, face ostitive imprisonment. This means that if they refuse to cooperate with authorities, they are presumed unreformed and are denied parole eligibility. The Viola v. Italy 2018 case examined the ostitive system, where the court found that the absolute presumption that non-cooperation indicates lack of rehabilitation violated Article 3. The court ruled that emotional reasons, e.g., fear of retaliation or protecting loved ones, could justify non-cooperation, and that this should not automatically prevent a prisoner from being considered for parole. Emotional ties to others should not be treated as evidence of criminal behavior, and forcing cooperation under these circumstances was found to be inhuman and degrading. In response, Italy amended its laws to allow for parole eligibility even if a prisoner has not cooperated with authorities, provided they show no ongoing criminal association. Ostitive imprisonment was found to be unconstitutional and was adjusted to offer a path to rehabilitation. Key takeaway. Life imprisonment is not inherently a violation of Article 3, but the absence of parole or the lack of sentence review can create a breach of human rights. Prisoners must be given a chance for rehabilitation and should have a prospect of release after a reasonable period. Whole life orders and ostitive imprisonment are particularly sensitive to human rights scrutiny, especially when they foreclose any hope for rehabilitation or reintegration into society. Theories of criminalization seek to answer the fundamental question of what conduct the legislator can legitimately criminalize. This question arises because the formal definition of crime, a violation of law sanctioned by punishment, does not offer insight into which kinds of conduct may be criminalized. This definition is a formal notion that leaves the scope of criminal behavior broad and uncertain. Substantial definitions of crime: what gets criminalized, who decides, and when does it go too far? It's not just about the law saying, hey, you did this thing, and now we lock you up. No. It's a little more nuanced. The law has got to figure out which acts are so heinous, so harmful, that society's got to step in and make them illegal. Now, you're probably thinking, what kind of conduct can the law really punish? Well, let me tell you. First up, we've got 2 kinds of crimes, okay? The mala incetis are the ones everyone agrees are just plain wrong. I'm talking murder, theft, those kind of things. Everybody, everywhere knows their crimes. Mala quia prohibitano. Here's where it gets interesting. These are the crimes that only exist because the government said, hey, we don't like that, so we're making it illegal. Think drug possession. Illegal immigration stuff that's not inherently bad but got banned because some lawmaker decided to put their stamp on it. Now, the big question, Can the government just throw laws at everything? Not so fast. That's where theories of criminalization come in. They basically say, hold up, just because you can make something a crime doesn't mean you should. Because if we criminalize every little thing, we end up living in a world where the government's sticking its nose in all our business. And that's a slippery slope, my friend. So, these scholars, real smart people, mind you, came up with a couple of ways to stop the state from getting too crazy. You've got your continental European tradition, where the idea is only criminalize stuff when it really matters, when there's a real societal harm. And then you've got the Anglo-American tradition, where they're all about individual rights and keeping the government's hands out of your pocket, so no over-criminalizing unless it's absolutely necessary. Bottom line, criminal law's got to strike a balance. You don't want the state locking up people for things that don't hurt anyone, but you also don't want to let people get away with stuff that might cause harm to others. It's about smart lawmaking, just like making sure your lawyer doesn't get you into more trouble than you started with. So, here's the deal with continental European tradition. This is all about the idea of legal goods. What does that mean? It means criminal law can only step in to protect things that society says are important stuff, like life, health, property, sexual autonomy, personal integrity. These are the legal goods society values, and the criminal law exists to protect them. You've got this guy, Franz Birnbaum, who came up with the idea of legal goods. These are interests that pre-exist the law, meaning society already sees them as important before the law even steps in. For example, if someone threatens your life or steals your property, those are socially relevant interests, and that's what criminal law protects. But here's the catch. Not every bad act should be criminalized. The state's intervention should only be for those acts that can harm these important legal goods. In other words, the state can't just go criminalizing whatever it wants. It's all about limits to state power. Now, fast forward to Nazism, the regime was all about using the law to crush any opposition. The Kiel School didn't like this. They were worried about totalitarian states using criminal law with no limits, just punishing anyone who disagreed with the state. And this idea of protecting legal goods became central in the 1960s and 70s as a way to decriminalize things that were once criminal under a repressive regime. For example, homosexuality was decriminalized because society realized there was no good reason to criminalize consensual acts between adults. No legal good was being violated there. But there's a problem with this theory. It's kind of vague. What exactly counts as a socially relevant interest? Is it really just about what society thinks in the moment, or should there be limits? Some scholars want to make it stricter by tying it to fundamental constitutional right stuff that's written into the Constitution. But that could be too narrow. What about things that weren't even considered important when the Constitution was written? So, to fix that, we've got something called the principle of offensiveness. This means that a crime needs to actually offend or harm a legal good. If it doesn't, it could be declared unconstitutional. For example, once upon a time, it was a crime to disrespect a state flag. But that was unconstitutional because it didn't protect any legal good. Then there's Claus Roxen, who threw in his 2 cents. He said criminal law should only protect interests that are necessary for the free development of individuals or for the functioning of the state. No overreach. So in a nutshell, criminal law in the continental European tradition is supposed to focus on protecting important societal interests and shouldn't just be used to punish anything and everything. The state's got to respect limits, and it can't just lock people up for things that don't harm those core interests. It's all about balancing power and making sure that laws are justifiable and protect genuine social goods. So, the Anglo-American tradition brings us the harm principle, courtesy of the OG of liberty, John Stuart Mill. Back in 1859, in his book On Liberty, Mill said, "Yo, the government can't just go around messing with people's freedom unless they're harming others." What's the deal with the harm principle? The big idea is freedom is king. The state only steps in when someone's actions are hurting others. No harm, no foul. But what counts as harm? Let's break it down. 1. private harm. Serious and substantial, we're talking about obvious bad stuff, things like murder, assault, or theft, those mala and se crimes that are wrong everywhere. Not every little scratch or insult counts here. Mill's harm principle says it's gotta be serious harm. That's where the de minimis principle comes in. Don't waste time on trivial stuff. 2. Risk of harm. Sometimes you've got to play it safe. If someone's actions pose an unreasonable risk of harm, even if no one's hurt yet, you can still step in. Think reckless driving. It's about preventing harm before it happens. 3. Public harm. Collectively shared interests. This is where things get juicy. Not all harm is personal, some harm is public, spread across a whole society. Examples? Tax evasion, you're not robbing your neighbor, but you're ripping off society's wallet. Bribery and corruption hurting institutions that everyone relies on. Environmental harm polluting the planet doesn't target a single person, but we all suffer. The harm here might feel diluted, but it's still real. These collective harms justify criminalization because they chip away at the greater good. When is criminalization legit? Here's the TL. DR on what Mill's harm principle says is fair game for criminal law. Private harm, serious, substantial, and undeniable harm to individuals. Risk of harm, unreasonable risks that could lead to harm. Public harm, actions that damage institutions or interests important to the whole community. The harm principle, great but not perfect. Mill's harm principle, classic. It's about freedom, baby. The government only steps in when someone's actions hurt others. But there's a catch. What happens when it's not about direct harm, but something that just makes people go, ugh? Here's where the critics come in. Collective interest is fuzzy. Sure, protecting public peace and security sounds great, but defining what that actually means, it's like trying to nail Jell-O to a wall. What counts as public harm? And how do we make sure we're not trampling on people's freedoms for vague reasons like keeping order? Example. Think of cases like criminalizing protests, immigration, or strikes where the harm isn't clear, but the state uses public security as an excuse. Balance is key. The state can't just go wild, criminalizing everything that makes folks uncomfortable. The sacrifice of individual freedom should only happen when it's essential for society to function. Think corruption-free governments or clean air. Enter Joel Feinberg. The offense principle. Mill wouldn't criminalize actions just because they're offensive. But Feinberg? He says, hold on a second. Some stuff might not harm you, but if it's offensive enough to society, it's fair game for criminal law. Feinberg's social experiment. Imagine this. You're on a bus and someone starts eating garbage, or maybe engaging in some explicit activities. No one's directly harmed, but you're feeling seriously grossed out. That gut reaction, Feinberg argues, is enough to justify some criminal laws. Public nudity, desecrating a corpse, spewing hateful slurs. All these can be criminalized because they cause offense, not harm. But hold on, what's the problem with offense? Feinberg's approach isn't bulletproof. Here's the rub. Subjective emotions. Offense depends on feelings, and feelings, they're fickle. Today's offensive might be tomorrow's no big deal. Example. Public kissing was once offensive in many cultures. Now, a shrug. Prejudice alert. People's reactions can come from bias or outdated morals. Should we let someone's personal disgust dictate the law? Where's the line? How do we decide what's offensive enough to be criminalized? Feinberg doesn't have a crystal clear answer. A little twist. Harm to self. Some scholars argue we should stretch the harm principle to include harm to oneself. Think self-harm, dangerous drug use, or reckless behavior. Mill would probably say that's their choice. But modern scholars, they're wondering if the state has a role in protecting people from themselves. Closing argument. The harm principle? Solid foundation. But when life gets messy, you need a little more nuance. That's where Feinberg's offense principle comes in. It's not perfect, it's got emotion and bias baked in, but it's a way to handle those ooh moments that harm the soul of society. The big question: how far should we go to balance freedom with societal norms? Harm to self, when the state becomes Big Daddy. So, here's the big question: should the state step in to stop you from hurting yourself? Enter legal paternalism, the because I said so parenting move of the legal world. It's like the state saying, listen, kiddo, I know what's best for you. This breaks down into two flavors. Hard paternalism. Picture this. You're an adult making a risky but fully conscious decision, and the state swoops in like a helicopter parent. Example: euthanasia laws where you're ready to call it quits, but the law says, not so fast. Critique: this is the ultimate buzzkill for autonomy. Who gets to decide what's harmful if you're fully aware and okay with it? Soft paternalism. Now, this one's a bit more chill. The state only steps in if you're not in a position to decide for yourself, like when you're misinformed or coerced. Example: a law ensuring you understand the risks of gambling before letting you blow your paycheck. Defense: it's not crushing your freedom, it's just making sure you're really the one in charge of your choices. Legal moralism. Morality with a side of handcuffs. Now, here's where it gets spicy. Should the law care about morality? Enter legal moralism, which says criminal law should protect moral values. The debate splits into two camps. 1. Straight moralism. Think of this as true morality enforcement. The state's out here like a moral referee, deciding what's right and wrong. Example: laws banning prostitution or public nudity because they're deemed immoral. Critique: who decides what's moral? Majority rule? A select group of moral elites? It's a slippery slope, and minorities get trampled. 2. Functional moralism. This one argues that shared moral values are the glue holding society together. Protect those values or society risks falling apart. Example: laws against desecrating national symbols because they're seen as essential to collective identity. Critique: where's the evidence? Does society really crumble if certain taboos aren't enforced? Most critics say this is more fear-mongering than fact-based policy. The bigger picture: freedom versus control. Here's the deal. Laws rooted in paternalism or moralism can clash with the idea of personal freedom. Shouldn't criminal law focus on protecting rights and fundamental collective interests like life, property, and public safety rather than stepping into people's private lives or moral choices? Paternalism's dilemma: at what point does protecting people from themselves become a prison of good intentions? Moralism's trap: how do we avoid using morality as a cover to enforce prejudice or suppress minority views? Some examples. 1. Homosexuality. The criminalization of homosexuality provides a vivid illustration of morality clashing with individual liberty. Historically, moral justifications were invoked to restrict same-sex relationships. Germany, 175 CE. The German Criminal Code criminalized sexual relations between men for over a century. While restricted to minors in 1975, the provision was entirely abolished in 1994. This evolution reflects the gradual dismantling of moralistic laws as society grew more inclusive. Landmark case: Lawrence v. Texas, 2003. In the United States, the Supreme Court ruled that laws criminalizing same-sex conduct violated the 14th Amendment's Due Process Clause. Outcome: it emphasized the right to privacy and invalidated sodomy laws nationwide. Significance: this decision affirmed that moral disapproval alone is insufficient grounds for criminalization, championing the principle that law should protect individual autonomy unless harm to others is evident. 2. Incest. Incest remains universally criminalized, often justified on public health and societal stability grounds. However, debates around consensual adult relationships and the limits of legal paternalism persist. Case: Stubing v. Germany, 2012. Patrick Stubing and his sister Susan Karolewski challenged Germany's incest laws, arguing that they infringed on their Article 8 right to private and family life under the European Convention on Human Rights. Court's ruling. The European Court of Human Rights upheld the criminalization, citing protection of family integrity, prevention of potential genetic risks to offspring, preservation of societal moral standards. Analysis. The court leaned on the idea that certain moral and public health interests justify restrictions on individual autonomy, even in consensual adult relationships. 3. Abortion. Abortion laws reflect deep tensions between a woman's right to autonomy and the state's interest in protecting potential life. Landmark case, Roe v. Wade, 1973. The U.S. Supreme Court recognized abortion as a constitutional right under the Due Process Clause, framing it as an aspect of privacy. This ruling balanced a woman's autonomy against the state's interest in protecting prenatal life. Reversal, Dobbs v. Jackson, 2022. Nearly 5 decades later, this right was overturned. The court ruled that abortion is not constitutionally guaranteed, leaving its regulation to individual states. Implications. States can now criminalize abortion, prompting questions about reconciling criminal laws with constitutional rights. Balancing constitutional rights with criminalization. At the heart of these debates lies the principle of non-contradiction. The state cannot criminalize conduct that is protected by constitutional rights. This principle underscores the tension between competing interests. Freedom versus societal morality. Should morality guide criminal law? Examples like incest and homosexuality demonstrate the dangers of imposing subjective moral standards, particularly when they infringe on autonomy and privacy. States' obligation to protect rights. When constitutional rights are at stake, the state must act as a guardian of liberties. Criminalizing protected behavior, such as consensual same-sex relations or abortion pre-Dobbs, undermines the state's legitimacy. Balancing opposite interests. The challenge lies in reconciling individual freedoms with societal concerns, e.g., public health, moral cohesion. Criminal law should intervene only where harm is clear, direct, and substantial, avoiding unnecessary encroachment on personal autonomy. Conclusion. These examples showcase the complexities of criminalization in morally charged contexts. The state's power must be carefully wielded, prioritizing individual rights while safeguarding public interests. Ultimately, criminal law should aim to uphold justice without becoming a tool for moral policing or unwarranted intrusion into private lives. Constitutional limits. Prohibition of incrimination. Here's the deal. Lawmakers can't go around making laws that trample on your constitutional rights. That's like a mall cop trying to arrest you for walking too fast. Doesn't fly. But hey, sometimes rights bump into each other, and that's where things get messy. 1. Lawmakers, chill out. Right to strike Italy's art. 40. Workers gotta strike, right? It's in the Constitution. You can't slap handcuffs on them for exercising their rights. But what if your freedom to do your thing messes with someone else's vibe? Freedom of speech versus dignity? Speak your mind, but don't go around trashing someone's good name. That's where defamation laws come in, keeping things fair. 2. State, protector or helicopter parent. Here's a curveball. Not only does the state have to stop messing with you, but sometimes it's got to step in and save your bacon when others cross the line. The big question: when does the state step in? Criminal laws aren't for every little squabble. They're the last resort, like breaking out the duct tape when everything else fails. 3. Criminalization. When it's a must. Implicit duties. The state doesn't need to punish every bad thing. It steps in only when absolutely necessary. Like if someone steals your wallet, sure. But if your neighbor's music is too loud, maybe call the HOA, not the cops. Explicit duties. When international treaties or constitutions call the shots, the state's hands are tied. Example: torture. It's a big no-no. Laws against it aren't just nice, they're mandatory. 4. Torture in Italy, a legal mess. Italy didn't have a law against torture until 2017. That's right, 2017. Gate Genoa 2001. Protesters got smacked around like piñatas. The perpetrators? Nada. No real punishment. The clock ran out thanks to weak laws and statutes of limitations. The fix? After getting roasted by international courts, Italy finally made torture a crime. Took a while, but better late than never, right? 5. Rights in a tug of war. Sometimes your rights and someone else's are like two dogs fighting over the same bone. Speech versus privacy. Say what you want, but don't cross the line into defamation. Keep it classy, folks. Protests versus public order. March in the streets, hold your signs, but don't block ambulances or trash the place. 6. The bottom line. Criminal laws aren't a free-for-all. They've got to stay in their lane and not stomp on your rights. But when things get serious like torture or defamation, the state's got to step up and keep the peace. So, when lawmakers try to go overboard, just remember, better call Constitution, your rights are the real MVP. All right, folks, listen up. You've got your big legal question. Can I help someone off themselves or not? In the UK, we've got something called the Suicide Act of 1961, which says if you help someone take the big sleep, even if they ask for it, you're looking at a 14-year vacation in prison. And trust me, that's not the kind of vacation you want. But don't worry, there's a little light at the end of the tunnel because the European Court of Human Rights says, hey, UK, you do you. You've got a lot of leeway here. Now, if you look over to places like the Netherlands, Belgium, or even Canada, these guys are playing a different game. They're all about autonomy. In the Netherlands, euthanasia and assisted suicide are totally kosher. As long as the patient's making the call with a clear head, no mental illness clouds the judgment, and they're suffering in ways no amount of medical wizardry can fix. Belgium's even gone wild. They'll let minors make the call if they're terminally ill and in pain. And these countries aren't alone. Switzerland, Spain, Portugal, you get the idea. They're saying, life's your call, and if you're ready to check out, we're not going to stand in your way. So, if you're wondering whether to put an end to someone's suffering, check out the laws in your neck of the woods. The rules, they're all over the place, my friend. Just make sure you've got all your ducks in a row, or you might find yourself in a world of hurt. Some countries are starting to realize that when people are suffering, they should have the right to make their own decisions, especially when it comes to ending their life on their own terms. Now, don't get me wrong. Some places still want to keep things all paternalistic and control the situation. But others are starting to understand that if a person is in unbearable pain, mentally competent, and wants to end it all, they shouldn't be thrown in jail for making that decision. Now, you've got your big players like the Italian and German courts telling the government, hey, let people make their own choices when they're suffering. We've got the European Court of Human Rights saying, you can't force someone to stay alive if they don't want to. And just to make it even spicier, there's the whole thing where if you refuse treatment, even if it could save your life, that's your right too. It's all about self-determination. You get to call the shots on your life. Then there's cases like Pier Giorgio Welby in Italy. Dude was suffering, asked to stop the treatment, and bam, no jail time for the doc. But what about the people who are in a coma, can't speak, can't tell you what they want? We're talking the Eliwana Inglaro case here. Family said, stop the machines. And the court finally said, you got it. And then, of course, there's the sad cases with kids, like Charlie Gard and Parfit v. UK, where the courts are making tough decisions on what's in the best interest of the child. It's all about balance, folks. Self-determination, best interests, and making sure the law's got a proper framework for all this. Now, is that clear as day or what? It's a mix of compassion and rules, but ultimately it's about respecting the individual's choice. Make sense? Good. So, here's the deal, folks. You've got this whole mess of assisted suicide, where someone wants to check out early and asks for help from a medical professional. In a lot of places, that's a criminal act, because helping someone off themselves could get you slapped with a charge of aiding suicide. But wait, there's a catch. Some countries don't punish it, and they're starting to get real picky about when it's okay to help someone, especially when it's a case of someone who's got no way out due to an incurable illness or living off artificial life support. Take the Cappato case in Italy, for example. Here's the twist. Italy says suicide is a crime under Article 580 of the Criminal Code, but their constitutional court said, hold up criminalizing assistance to suicide doesn't violate the Constitution, as long as the person asking for help is fully capable, they're mentally aware, and they know they're about to die. So no, it's not a free-for-all, but it's not a blanket punishment either. If someone is in their right mind, knows exactly what they're doing, and has no hope for recovery, then the state can't stop them from making that call. This is where it gets international, folks. Canada and Germany are on the same page, with similar rulings where they've said, hey, if the person's mentally competent and in real pain, you can't just force them to suffer. Now let's talk about active euthanasia, which, in most places, is a no-go. But here's where things get a bit juicy. Belgium, yet. That's the place known for its lax rule. A case in 2023, Mortier v. Belgium. A woman suffering from severe depression asked for the big exit, and they granted it based on her request and the fact that doctors said her pain couldn't be fixed. Boutin, here's the kicker, her son didn't know. And when he found out, he wasn't too thrilled. He appealed to the European Court of Human Rights, saying her rights were violated. The court agreed that the process had flaws, not because of the euthanasia itself, but because the doctor performing the procedure was the same doctor who was supposed to check if it was legal. That, my friends, goes against the independence of the review process. So, the court said, yeah, you might be allowed to die, but not like that someone else should have double-checked everything. So, in the end, it's all about autonomy, but with a big dose of procedure. It's one wild ride through the world of life, death, and how far governments can go in protecting your right to choose when to check out. Not all heroes wear capes, but they sure do hold the power to decide your fate, huh? And we're going full legal eagle here. This is a foundational rule in both criminal law systems, whether it's the common law or civil law. The idea is simple but powerful. No crime and no punishment without law. This goes back to the great German legal thinker Feuerbach, and it's embedded in the principle of nullum crimen, meaning no person can be convicted or punished unless their conduct is explicitly defined as a crime in the law. You can't just wake up one day and say, hey, that's illegal. No. The law has to be clear and specific about what's criminal and what the punishment will be. Now, let's break it down even further. There are two key rules here. First, you can't convict someone unless the crime they committed is written down in law, no surprises. Second, even if they are convicted, they can't face a harsher punishment than what was outlined when the crime was committed. Fair, right? It's all about keeping things predictable and just. The law should clearly define the crime and the penalty. Then, the principle branches into different sub-principlesso. Bear with me. We've got nullum crimen sine legea scripta, which is the principle of legislationally written law counts here, especially in civil law countries. Then there's nullum crimen nulla poena sine privilege, or non-retroactivity, which means no retroactive laws. In other words, you can't be punished for something that wasn't a crime when you did it. That's the real core of legality. And there's the principle of specificity, also called maximum certainty in common law, where the law has to be clear enough for a reasonable person to understand. Then we have principle of strict construction, which is all about how judges interpret the law. If a law is vague, the judge should favor the defendant, because the law shouldn't be used against someone if it's not crystal clear. But why does all of this matter? In the civil law tradition, it has its roots in the Enlightenment. Back then, it was about shifting from absolute power to the idea that only a democratically elected parliament can make criminal laws. This idea is linked to the social contract theory. Citizens give up certain freedoms to the state, but the state via parliament is the only one with the authority to decide what's criminal and how to punish it. The idea behind this principle is a guarantee from abuse by the government or sovereign power. During the ancient regime, judges were just the king's lackeys, but now, thanks to thinkers like Montesquieu, we have the separation of powers. Parliament makes the laws, and judges just apply them. So, in civil law countries, judges don't get to go wild interpreting laws. They're supposed to apply the law literally, as written. However, in modern times, judges do sometimes get a bit creative in interpreting laws, though they're supposed to stick to the literal meaning. In some, the principle of legality is all about fairness, predictability, and keeping the government in check. No one should be punished by surprise, and no law should be twisted against someone. It's a fundamental pillar of justice in modern legal systems. Now, common law? It's a hybrid system where you've got written laws, sure, but also a hefty dose of unwritten laws that are shaped and refined by judges in the courts. This is where the principle of stare decisis comes into play, basically. Lower courts have to follow the decisions made by higher courts. It's all about consistency, folks. Higher courts make the big calls, and lower courts have to follow, creating certainty in the law. Now, let's talk criminal law. In the common law world, the principle of legality isn't all about the separation of powers, no. It's not just the parliament cranking out the laws. Judges are also in the mix. And sometimes they've got the power to be creative. That means the law doesn't just come from statutes. It comes from the court's decisions, too. The legality principle in common law goes beyond just not breaking the separation of powers. It's about making sure people know what the law is and what's going to happen if they break it. No surprises, right? People have to be able to understand the law, and it's got to help them plan their life. This leads into certain Thai citizens should always know where the line between right and wrong is, so they don't get slapped with a conviction out of the blue. Now, here's the kicker: legality also ties into deterrence. Citizens need to know the consequences of their actions before they do them. It's all about preventing crimes by making sure people can weigh the benefits against the consequences. And guess what? It also ties into culpability. You can't hold someone accountable if they had no idea what was coming down the pipeline. If they didn't know the consequences, how can they be blamed? So, let's recap. The principle of legality plays a huge role in criminal law. It's about certain type people need to know what the law is, so they can make informed decisions. And while there's a difference between civil and common law systems, that line is blurring nowadays. Civil law is all about written laws, while common law, it's a mix of statutes and court-made decisions. And judges, they're not just robots reciting the law. They've got a creative role to play now, too. All in all, the principle of legality keeps everything in check, guiding citizens and making sure the law doesn't throw them for a loop. Simple as that. The principle of legality is accepted and codified in almost all democratic states, and it is almost a requirement of the rule of law. It can be seen in almost all national constitutions, such as Article 25 of the Italian Constitution, which is very important in relation to criminal law. No one can be deprived of their natural judge established by law. No one can be punished unless by a law that has come into effect before the act was committed. No one can be subjected to security measures except in the cases provided by law. Similarly, Article 25, Section 1 of the Spanish Constitution states, no one may be convicted or sentenced for any act or omission that did not constitute a felony, misdemeanor, or administrative offense according to the law in force at the time it was committed. Article 103, Section 2 of the German Constitution declares, an act may be punished only if it was defined by law as a criminal offense before the act was committed. The term law in these articles always refers to written law, because we are in a civil law tradition where these concepts are passed by legislative authority. Therefore, the principle of legality is also a principle of legislating, meaning that law is written law, and it is linked to the political origins of the separation of powers. This principle can also be found in several supranational instruments protecting human rights. Article 7 of the European Convention on Human Rights ECHR states, "No one shall be held guilty of any criminal offense on account of any act or omission that did not constitute a criminal offense under national or international law at the time it was committed. Nor shall a heavier penalty be imposed than the one that was applicable at the time the criminal offense was committed." Article 49 of the Charter of Fundamental Rights of the European Union, CFREU, further elaborates, "No one shall be held guilty of any criminal offense on account of any act or omission that did not constitute a criminal offense under national or international law at the time it was committed. Nor shall a heavier penalty be imposed than the one that was applicable at the time the criminal offense was committed. If, subsequent to the commission of a criminal offense, the law provides for a lighter penalty, that penalty shall be applicable." Article 15 of the International Covenant on Civil and Political Rights, ICCPR, at the level of the UN, is another cornerstone of international human rights law, adopted by the General Assembly in 1966 and entering into force in 1976. All of these principles trace back to Article 11 of the Universal Declaration of Human Rights, one of the first normative formulations of this principle. Article 49 of the CFREU goes beyond the guarantees of Article 7 of the ECHR and Article 15 of the ICCPR, because it also provides for an exception to the principle of non-retroactivity of criminal law when it is more favorable for the offender. Specifically, the last sentence states, "If, subsequent to the commission of a criminal offense, the law provides for a lighter penalty, that penalty shall be applicable." Article 7, ECHR, no punishment without law. Listen up, folks. Article 7 of the European Convention on Human Rights is all about making sure you can't get punished for something that wasn't even a crime when you did it. No one, I repeat, no one, can be convicted of a criminal offense if it wasn't considered a crime when they did it. And don't even think about getting slapped with a heavier penalty than the one that was in place when you committed the act. This is the law looking out for you. And it's not just some little suggestion, this is absolute. You can't mess with it, even in special times like when the world's on fire. It's in the same category as Article 3, which bans torture. This is the real deal when it comes to your rights. What's the principle here? It's simple. Only the law written and official gets to say what's a crime and what's not. Nobody else has that kind of power. What does law mean under the ECHR? So, you're thinking, all right, I get it. But what exactly does law mean here? Well, in the ECHR world, law isn't just the stuff that's written down in a statute. It's also the judge-made law, the case law, the decisions that come from the bench. And here's the kicker, it doesn't matter which legal tradition you come from. The ECHR is all about autonomous interpretation. What does that mean for you? It means that the court doesn't care about what your country's legal system says about a particular term. The court's going to decide what law means in its own way, so that everyone's rights are equally protected no matter where they're from. Autonomous interpretation. Civil versus common law. You see, Article 7 is flexible. The term law doesn't just mean the written statutes, it also includes judge-made law. This is important because in the ECHR world, it's not just about what's written down in a law book, it's about how the courts interpret and apply that law. The courts don't just follow the book. They get to decide what laws really mean and how they apply to the case in front of them. It's like the judges can interpret the law to make sure it works for everyone. So, what does this mean for you? Let's break it down nice and easy. The law isn't just about having a statute on the books. It's about accessibility and foreseeability. Accessibility. You should be able to access the law. It's got to be public. It's got to be out there where you can see it. No hidden rules. Foreseeability. You've got to be able to know what will happen if you step out of line. What's the penalty? You should be able to see that coming, like a speed bump on the road. If you're going to break the law, you need to know exactly what's coming your way in terms of consequence. Why does this matter? If a judge makes a decision, and that decision makes sense based on the law, like it's clear what the law means, even if it wasn't spelled out exactly then, the principle of legality is safe and sound. No violation here. But if a judge comes in and twists the law in a way that's completely unpredictable, that's a violation of the principle of legality. Courts can interpret, but they can't create brand new laws. They don't get to just pull stuff out of thin air. And here's the kicker: this applies even to civil law systems. It's not just about what's written in a book. If the court interprets the law in a way that no one saw coming, that's a problem. You have to be able to predict what's going to happen when you're up against the law. Foreseeability is key, my friend. All right, let's break this down nice and easy. Foreseeability is key to understanding how the European Court of Human Rights, ECHR, interprets the law when it comes to criminal charges. The court doesn't just look at things one way, it mixes up different interpretations. And here's how they do it. Evolutionary foreseeability. The first way the ECHR thinks about foreseeability is how social attitudes and culture change over time. Basically, as society evolves, so does the law. If society starts to view certain actions differently, it becomes foreseeable that the law will change too. You can predict that as things evolve, certain actions may be criminalized. So, foreseeability here is all about social development. Subjective foreseeability. Next, we've got the subjective view. This is about you. It means that whether you could foresee the criminal charge depends on your personal abilities. If you have a specific knowledge or skill, you might be able to predict what the law says. So if you're a legal expert or have knowledge of the law, it's on you to understand what could happen. Objective foreseeability. And then there's objective foreseeability. This is the clearest and most guaranteed version. It's all about the law being clear enough that anyone with basic legal understanding can foresee the criminal charge. If the law and the case law are clear and unambiguous, there's no excuse for not seeing the consequences of your actions. This is the ideal form of foreseeability. The case of SW v. UK, 1995. All right, listen up. You've got your man SW, just a regular guy, right? But he finds himself in a bit of a pickle. His wife wants to leave him, and he's not having any of it. So what does he do? He tries to force her into sex. Not the smartest move, but hey, let's see where this goes. Now, this whole situation happens to be before 1991. And guess what? There's this old rule, a nice little legal nugget known as marital immunity. What's that, you ask? Well, in simple terms, it says that a husband couldn't rape his wife because once they were married, he had irrevocable consent to her body. Yeah, sounds a little shady in hindsight, but hey, that was the law. People use that defense all the time, husbands walking free while their wives got the short end of the stick. But here's the twist. The law changes. Boom, 1991 comes around, and the House of Lords says, nah, that marital immunity stuff, gone. See ya. So now, if a husband rapes his wife, guess what? He's going to jail. RVR, baby. That's the case that flips the script. But wait, SW didn't get the memo, did he? He still thought he was untouchable under the old rule. So, what happens next? He gets charged with rape, and he decides to take it all the way to the ECHR, the big leagues of human rights. His defense? Hey, when I did it, the law said I was in the clear. You can't punish me for something that wasn't a crime back then. Seems reasonable, right? Wrong. The ECHR steps up and says, hold on a minute, pal. They tell SW that, yeah, maybe it wasn't technically a crime when he did it, but society was already changing and it was foreseeable that the law was going to evolve. They even call it the natural evolution of the law, the kind of thing that people should see coming a mile away. The law was changing, society was changing, and you can't just pretend like you didn't see it coming. So guess what? Foreseeability was the name of the game. SW's defense? Denied. He got convicted, and he did time. Why? Because even though he committed the act when the law was different, it was clear as day that the law was going to catch up with him, and he should have known better. And there you have it, folks. A little legal evolution, a little change in society, and a guy who got caught not seeing the writing on the wall. So remember, when the law changes, you better keep your eyes open, because the ECHR isn't about to let you get away with it. Foreseeability, it's a real thing, and SW learned that the hard way. Case closed. All right, here's the rundown of Del Rio Prada versus Spain. Grab your seats, because this one gets a little messy. Facts. We're dealing with a lady born in 1958 who got tangled up in all sorts of criminal activities between 1988 and 2000. She was part of a terrorist group, got caught with weapons, explosives, and even murder. Long story short, she ended up with 8 separate sentences totaling over 3,000 years. Yes, you heard that right. But the Spanish court, using its criminal code, decided to make life a bit easier by capping her total prison time at 30 years. Now, while she's locked up, in 2008, she requests some remission of her sentence. Basically, she's asking for a break up to a third of her sentence could be knocked off for good behavior and work done in prison. Sounds fair, right? But here's the kicker. The Spanish court rejected her request, thanks to something called the Pero Doctrine, a rule set by the Supreme Court in 2006. According to the Pero Doctrine, her sentence reductions wouldn't apply to the maximum 30 years. Nope. Instead, they would be applied to each of the individual sentences she had received. So, instead of getting time knocked off the total 30-year sentence, she was now stuck with sentence reductions only applying to each individual charge. Essentially, it meant she'd be locked up for years longer before seeing any benefit. Now that's a raw deal. Claim. She takes her case to the European Court of Human Rights, ECHR, arguing that this retroactive change in the law is a violation of Article 7, which is all about the principle that criminal laws can't be applied retroactively in a way that's less favorable to the accused. She claims that, instead of having the maximum 30-year sentence, this new rule forces her to serve a longer sentence, effectively imposing a new penalty that she could not have predicted at the time of her offense's decision. The ECHR was not on her side. The court said that when the applicant was sentenced, the law was clear enough for her to foresee that she would serve 30 years maximum. They also noted that she knew that any sentence reductions would be subtracted from that 30-year term. However, they didn't buy the Perot Doctrine being foreseeable. The court said that applying the Perot Doctrine retroactively was not something she could have predicted, given that she believed she was serving a 30-year maximum. When she was convicted, the law was written in a way that she could reasonably have understood the limits of her sentence. But the Perot Doctrine was an unexpected change. So the ECHR found that the retroactive application of this new rule was a violation of Article 7, as it was not for conclusion. The Perot Doctrine was a legal curveball that the applicant couldn't have seen. The decision violated her rights under Article 7 because the application of this new criminal law wasn't something she could have foreseen at the time of committing the crime. Retroactive changes to criminal law that make things worse for the defendant, that's a no-go under the ECH. In simple terms, the court slapped down Spain for throwing the Perot Doctrine into the mix, which made the applicant's sentence far worse than she could have imagined when she first committed her offense. Violation of Article 7, retroactive application, and a serious lesson in legal predictability. You've got this lady in Spain, right? She's been convicted of all kinds of nasty stuff, terrorism, weapons, explosives, the works. The court hands her a 3,000-year sentence. Yeah, you heard that right. But the Spanish system, being a bit more forgiving, says, hey, we'll cap this thing at 30 years maximum time served. Fast forward, she's been in prison doing her time, and then in 2008 she tries to get her sentence reduced based on the good work she's been doing in prison standard stuff, right? But then boom, the Perot Doctrine hits. And suddenly they're like, hey, forget about that 30-year cap. We're now applying sentence reductions to each individual crime you committed, one by one. Now, hold on a second. This is where it gets wild. She's thinking she's got a 30-year maximum, that's the deal, right? But Spain pulls this sneaky move and changes the game retroactively. She's already locked in, doing her time, believing she knows the rules. But boom, they change it. And now she's stuck with more time than she thought she'd get. She appeals this, takes it to the ECHR, European Court of Human Rights, and guess what? The court says, nope, Spain can't pull this fast one. Retroactive laws, not cool. They say it was unpredictable and not foreseeable. When she was convicted, she had a reasonable expectation that her sentence was capped at 30 years. But now, thanks to this Perot doctrine, they've thrown a legal wrench in the gears, and that's not allowed under Article 7. Long story short, the ECHR slapped Spain for changing the rules mid-game. Retroactive changes? Not in this court. You can't change the law to make someone's punishment worse once they're already in the system. That's a big violation of Article 7. So, Spain got called out for trying to pull a legal fast one. Violation of human rights, my friend. And that, my friend, is how the ECHR dropped the mic on Spain, telling them, you can't retroactively change laws and make things worse for the accused. That's not how justice works. All right, Article 7 of the ECHR is like a legal guardrail that says, hold up, you can't change the rules after the fact. It specifically makes sure criminal laws don't get slapped on someone retroactively. So if someone does something, let's say today, and the law changes tomorrow, you can't suddenly hit them with a penalty they didn't see coming based on this new law. Here's the deal. Defining the offense. Imagine tomorrow, the Parliament passes a law saying skirts are now illegal and anyone wearing one gets a year in jail. But yesterday, no law existed about skirts. Well, yesterday's skirt wearers shouldn't be punished because the new law didn't exist back then. They can't be punished for something that wasn't a crime when they did it. So, retroactive crime creation. Not gonna fly. Case example. Shaw v. DPP 1962. A guy made a magazine with ads for prostitutes when prostitution was not illegal. But the court said, hey, he was guilty of a crime anyway and created a new law out of nowhere. Problem? This was retroactive and it violated the principle of legality. You can't just invent crimes after the fact and throw someone in jail for them. That's like changing the rules in the middle of the game, changing the penalty. Now let's say robbery is punished with 3 years in prison today, but tomorrow the law changes to 5 years. But the dude who robbed the place yesterday can't suddenly face the new penalty. He's already done the crime, and he was expecting the 3-year penalty. You can't change the rules retroactively and slap a heavier penalty on him. That's just not how it works. Expanding existing crimes. This is a tricky one. Let's say rape was already a crime, but the law expanded it. Now, it includes cases where a husband rapes his wife, even though there used to be a rule that said marital immunity applied. So, rape's still the crime, but the law now includes new circumstances, and this gets a little more complicated. The ECHR said that even though there was a change in interpretation of what constitutes rape, the expansion of the existing crime to include marital rape wasn't a surprise. This was a social evolution, and it was foreseeable. But if we were to apply this change in a strict sense, that might not have been the case. Extending crimes to new facts. Here's a crazy one. Let's say a guy pushes his partner, causing her to lose the fetus. Now, is that murder? If Parliament passes a law later saying that a fetus is a human being, then pushing a partner and causing the loss of the fetus could be considered murder. But here's the catch. You can't retroactively apply this law to the crime that happened before it was passed. So, even if the courts change their mind later about whether a fetus is considered a human being, you can't go back and charge the guy with murder for what he did before the law changed. That's a no-go. Key takeaway. Article 7 is like saying you can't make the crime worse after it's already been committed. If the law didn't exist or wasn't clear at the time, you can't punish someone for something they couldn't have foreseen. That's not just unfair, it's a violation of their rights. So, retroactive changes to criminal law, they don't fly in the courts of the ECHR. Contrada versus Italy. Facts. Bruno Contrada, an Italian police officer, had quite the resume. He was number 3 in the Italian Secret Service during the 1980s, fighting the mafia like a top secret agent. But here's the twist. Contrada wasn't part of the mafia. He wasn't doing any direct dirty work for him. What he did was help the mafia by leaking sensitive police info. Between 1979 and 1988, he fed Cosa Nostra, the Sicilian mafia intel, on investigations and police plans. He wasn't part of the gang, but he was a major ally. But here's the legal pickle. In Italy, there wasn't a specific crime for helping the mafia without joining it. Instead, they had a law that punished being part of the mafia itself or participating in it. Some courts, especially in the 70s and 80s, tried to argue that helping the mafia should count as conspiracy, like you were working with them, even if you weren't officially in the organization. Fast forward to 1994, and the Court of Cassation, Italy's top court, finally says, yeah, this counts as a crime. But Contrada did his thing before 1994, so he wasn't expecting to get hit with charges for aiding the mafia. The claim. Contrada argued that at the time he helped the mafia, no one had clearly said that what he was doing was illegal. There was no law explicitly covering the crime of helping the mafia, just vague ideas. He claimed that the retroactive application of the law punishing him for something that wasn't clear at the time violated Article 7 of the ECHR, which forbids applying criminal laws to acts that weren't clearly illegal when committed. The Italian government argued back that the offense was predictable because there had been a debate in the courts about whether helping the mafia could be a crime. The government insisted that it was clear enough that his actions could be seen as aiding a criminal association. The decision? The European Court of Human Rights, ECHR, sided with Contrada. Here's why. The principle of foreseeability is crucial in criminal law. A person has to know when they commit an act whether it could be criminal. In Contrada's case, at the time of his actions, it was not foreseeable that aiding the mafia would be a punishable crime under Italian law. The legal basis for such a crime wasn't clearly defined until 1994, when the court started explicitly stating that helping the mafia could be criminal under the concept of conspiracy. The Court of Cassation's decision in 1994 finally made this clear, but it was after Contrada's actions took place. So, the ECHR said that Contrada couldn't have known that what he was doing was a crime at the time. Conclusion. The ECHR ruled that there was a violation of Article 7, which protects individuals from being punished for actions that weren't clearly criminal at the time. The retrospective application of the law making Contrada's conduct a crime after the fact was a no-go. The ECHR stood by the principle that you can't punish someone for something they couldn't have foreseen. In Saul Goodman terms, Contrada did some sketchy stuff with the mafia, no doubt. But when he did it, there was no clear law saying that what he was doing was criminal. So, when the courts changed their minds later and made it a crime, they couldn't turn around and say, hey, you're guilty for that stuff you did in the 80s. That's retroactive law, and the ECHR said, nope, not on their watch. So, in short, don't change the law and then go back and punish people for things they didn't know were illegal at the time. That's Article 7. The European Court of Human Rights, ECHR, ruled in favor of Contrada, emphasizing the importance of Article 7 of the ECHR, which guarantees that no one can be convicted for an offense that was not clearly defined at the time of the act. Article 7 holds a prominent place in the Convention system of protection, and its provisions cannot be derogated from under Article 15. Key points. Legal certainty. The ECHR stressed that only legislation and case law can define a crime, and individuals must be able to understand, based on the clear wording of the law or court interpretations, what acts would make them criminally liable. National case law's role? In Contrada's case, the Italian national case law was pivotal in defining the crime of aiding and abetting a mafia-type association. However, this crime was only clearly defined starting in 1994. When the Italian courts clarified that helping the mafia was punishable under conspiracy laws. Before that, the definition was debatable. Retrospective application. Contrada committed his acts between 1979 and 1988. The legal basis for convicting him only became clear after 1994. Thus, his conviction for aiding the mafia-type association was retrospective, which violates Article 7. A crime cannot be retroactively applied based on a legal interpretation that was not established at the time of the offense. Retroactivity of the more lenient criminal law. Imagine a guy gets nailed for something that's a crime today. like killing a fetus being treated as murder. He's convicted, does the whole trial thing, and then bam, next year, the law changes. Now, instead of being murder, it's downgraded to something way lighter. This new law, it's more chill. So, does our guy catch a break? Well, the general rule says laws apply as they were when the crime went down. But, and this is a big but, there's an exception when the new law is better for the defendant. Enter the concept of more lenient criminal law. The good news for defendants. If a law becomes less harsh after someone's convicted, the new kinder law can apply retroactively. Two ways this usually happens. Decriminalization. When a crime stops being a crime, example, adultery. Once upon a time, people in Italy could actually get locked up for cheating on their spouse. But in the 1970s, Italy was like, love's complicated, and abolished the law. Now, if someone got convicted before this repeal, they could get off the hook because the crime doesn't exist anymore. That's called abolitio criminisbu. The crime's gone. Reduced penalty. When the punishment gets lighter for the same offense. Example, if robbery's penalty used to be 10 years max, but a new law lowers it to 5 years, anyone convicted before that law should get the Article 7 and the ECHR. Now, here's where it gets interesting. Article 7 of the ECHR doesn't explicitly say anything about more lenient laws applying retroactively. But don't let that fool you. The European Court of Human Rights, ECHR, has said, yeah, it's in there just implied. In fact, Article 7 doesn't just stop courts from applying harsher laws retroactively. It also implicitly protects the idea that if the law changes for the better, defendants can benefit from it. So, even though it's not spelled out, the court reads it into the article. Other legal sources are much clearer about this principle. Article 49 of the EU Charter of Fundamental Rights. Article 15 of the UN Covenant on Civil and Political Rights. Article 9 of the American Convention on Human Rights. These guys straight up say that more lenient criminal laws should apply retroactively. But the ECHR, it just nods knowingly and says, don't worry, we got you. The key takeaway, the law changes for the better, you're in luck. Whether the crime gets erased or the punishment gets dialed down, the new law applies retroactively, of course. Even though Article 7 doesn't shout it from the rooftops, the ECHR has made it clear. Harsher? No retroactivity. Softer? Bring it on. So, next time the law gets chill, the defendant might just walk out with a lighter sentence or no sentence at all. Franco Scopola kills his wife in 1999. Back then, the law said if you did something that heinous, you'd get life imprisonment with daytime isolation. But the story gets spicier. Right after the crime, the laws in Italy change. New laws start offering options to lighten sentences. 1999 amendment. If someone opts for a summary procedure, a fast-track trial, they can get a reduction from life imprisonment to 30 years. 2000 amendment. Now the summary procedure still applies, but it only reduces life imprisonment to life without daytime isolation. 2002 conviction. Scopola is tried and gets life without daytime isolation based on the 2000 amendment. What's the problem? Scopola says, hey, I should have been sentenced under the 1999 law, which is way more lenient. So, he goes to the European Court of Human Rights, ECHR, for justice. ECHR decision. The ECHR sides with Scopola. Here's the play-by-play. Retroactivity of the lenient law. The ECHR says that Article 7 of the Convention isn't just about preventing retroactive harsher laws. It also implicitly guarantees the retroactivity of more lenient laws. If the law changes in favor of the defendant after the crime, the more lenient version should apply. Why? It's about fairness. Why keep applying an outdated, harsher punishment when society has moved on? Consistency with the rule of law? The court adds that this principle fits the broader rule of law. If a law is changed to make punishments lighter, it reflects society's evolving sense of justice. And applying harsher penalties that are no longer valid is unjust. Equality and non-discrimination. The ECHR introduces a twist. This isn't just about legality. It's also about equality. Equal cases should be treated equally. If someone committing the same crime today would get a lighter sentence, why should the person who committed it yesterday be treated worse? That's discrimination. Exceptions to non-retroactivity. The prohibition of retroactive harsher laws has exceptions. Cue the Eichmann case, where a Nazi official was sentenced in Israel under a law passed after World War II. Why was this okay? The crimes Eichmann committed, war crimes and crimes against humanity, were already universally condemned under international law when he committed them. Article 7.2 of the ECHR even acknowledges this exception. If the conduct was already considered criminal under international law, a retroactive national law is fine. Moral of the story. If you commit something like war crimes, don't expect the principle of legality to save you. Everyone knew it was wrong, law or no law. Key takeaways from Scopula. Article 7 isn't just about protecting defendants from harsher lawsuits, also about applying more lenient ones retroactively. Why? Fairness and equality, baby. The rationale isn't just legality, it's about non-discrimination. Treat similar crimes with similar consequences. Otherwise, you're just playing legal favorites. But wait, there's an exception. If a crime was already condemned by international law, retroactive laws can still apply. Looking at you, World War II war criminals. All right, let's talk about the maximum certainty principle, or as we might say in a legal showdown, the know before you go rule of criminal law. It's a trusty sidekick to the principle of legality, ensuring that people don't get blindsided by vague laws that leave too much room for guessing. The gist of it. This principle demands that criminal laws be as clear and specific as possible, so folks know exactly what's illegal and what penalties they might face. Think of it like a fair warning sign. If you're going to make a law, you better make it clear enough so people know what not to do. Otherwise, it's just not fair or legal. What it's tied to, non-retroactivity. If a law is too vague, it might as well be retroactive because nobody can tell what's allowed or not. It's like stepping into quicksand without even knowing it's there. Article 7 of the ECHR isn't just about banning retroactive laws, it's also about making sure laws are clear enough to know what conduct is punishable. Written law. Crimes and penalties need to be clearly defined in written law, not something courts or law enforcement make up on the fly. The law must give individuals the ability to understand, from the text alone, what's going to land them in hot water. Why it's important? Fair warning. Respecting citizens means they should know ahead of time what behavior could lead to punishment. No surprises. Preventing abuse? Vague laws open the door for arbitrary or discriminatory enforcement. If the law's unclear, police, judges, or prosecutors might interpret it however they want. That's a power trip waiting to happen. Balanced flexibility. The principle isn't about absolute certainty, because life is messy. It's about finding a balance. Laws need to be clear enough for people to understand, but flexible enough to adapt to new situations. Key takeaways. Laws don't need to spell out every possible scenario, but they must be defined well enough to provide reasonable guidance. Some vagueness is fine, but it should be kept to a bare minimum to prevent excessive rigidity and ensure fairness. The clearer the law, the less room for abuse, and the more respect it shows for citizens' rights. So, in essence, the maximum certainty principle is like a good contract. You want it specific enough to avoid misunderstandings, but not so rigid that it can't handle real-world situations. And remember, when the law isn't clear, the scales of justice tip dangerously toward chaos. Let's break down the principle of strict construction Saul Goodman style. Here's the gist. We're talking about how courts interpret the law, not how lawmakers write it. It's all about reading the rules like they're carved in Stonino creative spins allowed. This principle says judges have to play it straight when interpreting the law. Now, there are two flavors of this bad boy, depending on whether you're cruising through the common law streets or chilling in the civil law neighborhood. 1. Lenity Doctrine Common Law Edition. This is the defendant's best friend. If the law is unclear, confusing, or ambiguous, the court's gotta give the benefit of the doubt to the defendant. Basically, if there's a toss-up between two interpretations, the court picks the one that's easier on the defendant. Why? Because we don't want people getting hammered by laws they can't even understand. It's like a legal tiebreaker, and the house rules always favor the accused. Favor Ray, baby. 2. Prohibition of analogy. Civil law edition. In civil law countries, judges don't get to play mix and match with laws. They can't grab a rule from a similar case and slap it onto a situation that's not explicitly covered. For example, take Italy. Defamation gets a harsher penalty if it's done via the press. But what about online newspapers? The law doesn't mention those, and under this principle, judges can't extend the penalty by analogy. Bottom line, no stretching the law if it'll screw over the defendant. Now, if the analogy is favorable to the accused, sure, bring it on. But if it's unfavorable, no dice. Why it matters. This principle keeps the courts from turning into wildcard factories. It's a check against creative interpretations that could hurt defendants. Criminal laws need to be clear, precise, and predictable. And this principle ensures judges stick to the letter of the law, not their personal imagination. So, there you have it. Whether it's lenity in common law or the prohibition of analogy in civil law, it's all about keeping the game fair and square for the defendant.